Hello everyone, welcome back to another episode of the Darrell Brooks saga. On today's episode, we're gonna continue with the aftermath of the trial because trial is gone. We are over that. They both made their statements. Darrell did whatever he did. I don't know that if you call that a defense. And now the jury is out there, um, doing their thing. They're deliberating. They're basically filling up the pages, if you know what I mean. So we're gonna continue with that. Before that, I just want to say thank you. You guys know that we are right now on the restoration, rehabilitation of the channel because after the issue with the channel, it blew us out of the algorithm. So help me with your like, help me with your comment. Rory's here. Rory wants to tell you, please help us with the likes, please. Hello, everyone. So we can get back to where we were. It's gonna be a long road, but I'm here for it. As always, the link to the video in the description below. Let's start.
I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this moment from the state?
Thank you, Judge.
Anything from you, sir?
Yep.
Of course there is. If you ask Darrell Brooks see if he has something to say, he always gonna say yes.
So essentially, I'm gonna have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower.
Nope.
It is shower day for my pods. We only get 2 shower days a week.
So here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So
You
let
can't
me do
go.
this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work? How essentially how are charges able to be charged if all of the injured parties did not testify?
Why is he bringing up this now? I mean, remember when we were on the jury instructions way before, and he was just building his fort? That was the point where you needed to ask that question. Why are we instructing all those witnesses if they are not there? And at the beginning of the trial, when Zach was doing his opening statement, um, he said that they were not gonna bring everyone because it will be repetitive. It will be unnecessary. You don't want to make those people relive those moments. So that's why, Mr. Brooks.
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law, and I guess that's all I can really say about it at this point.
Yeah.
I got a point though.
I'm sorry?
I got a point though.
No.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof.
He's trying to be cute right now. He's trying to charm people. He's trying to be like, but I need, and it's disgusting.
and they have to convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss. The jury has the case, and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised because
Why does it have to be raised now, though? They're already discussing your future. The evidentiary phase is gone. The jury instructions are gone. Remember when you tried to delete or whatever, dismiss the bail jumping charge? That's where you needed to bring these issues. Now it's irrelevant.
essentially you can't. If no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you saying I need to make a motion?
Look at that gobbling face. And also, he keeps going with this. If the person is not here to testify, that means that no charge should be the living, breathing human being argument. And how's that going to work with the 6 people that cannot be there to testify, Brooks? They should dismiss those as well?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
When he put the time on, I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. So you'll have that, okay?
See, I didn't interrupt you. See,
I'm sorry?
that's
Why is he smiling? Why is he so proud that he didn't interrupt it? Wow.
see, I didn't interrupt you.
Thank you, I appreciate that. I would like the parties back in about a half an hour. Thank you, unless they have a question sooner.
Your Honor, do I have to go in that holding cell or do I got to get?
All right, it's 7:05, we're back on the record.
He needs to complain about everything.
I wanted to advise the parties that earlier today I received information from the clerk of court that she had received an email. The person sending the email had found a post on Justice for Darrell on Reddit, so it's a subreddit. I'm not familiar with how Reddit works, but and that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. Again, it's a subreddit called Justice for Darrell. All those Justice, the number 4, and Darrell, all no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. Of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will leave that for law enforcement to determine. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. And I hope we have the copies for the parties. And we'll provide.
All right. So basically, what happened is someone in there, we don't know who, and I don't think this is something that Darrell did or someone from him did. Someone went into Reddit and made a post saying that he was a member of the jury and that he was saying all that stuff about Darrell. But the issue with that is that when that was happening, the jury was already deliberating. So any changes to that post will mean that none of the juries would though. So that is a fake post. Someone made it on Reddit. I don't know why. But it got to the court, and now Darrell is going to hang on to that for his life because he has to.
Those. Go ahead.
I'm making sure you was
Go ahead.
first. What is this?
He just explained what it is.
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors.
Accept for value and return for value these documents. I'm confused. Was this? Oh, I'm sorry.
Go ahead.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. That email about this topic will be forwarded to the Sheriff's Department. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the District Attorney's Office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings. In viewing the content of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell.
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
I do want to state for the record that I have no involvement with this. I'm really like shocked like this even came to light just by skimming through it. These are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. This is no other way.
You notice how he's now really interested. He's really worried. He really wants to know who this person was. But what he doesn't realize is that we are watching him right now. Like, I know more about this case than some of the jurors because they were not there. So that's not the only way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
Thank you.
Well, I mean, it's pretty obvious that this would come from somebody who's actually.
He couldn't even bring himself to finish that sentence. He was like when he was thinking about what Susan said right now, it was like, oh no, it doesn't.
I think it's pretty clear.
It's not.
Well, I'm leaving it in the hands of law enforcement. At this time, it is simply being investigated. This was an anonymous post. And if either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, oh, go ahead. I'm sorry. Something else, Attorney Alpert?
A different topic, Your Honor,
Oh,
if
sure,
possible.
go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for, and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
Do you have any position on that, sir?
Yeah.
Of course he's gonna object. That's all he does. That's all he can do to stall.
I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the relevance and the admission of the exhibits. The issue is whether it goes back to the jury room.
So it would be only the exhibits that's been
Received.
So
Correct.
nothing new. Nothing's going to come out of the blue and be like, yo, yeah, we're going to.
Only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits, but
Why is he trying to be funny? I really don't get this part. Like, he's fighting for his life, basically, and he's trying to be funny? You think he takes this as a joke?
but I'm willing to have her printed off if you would like it.
I think it'd be helpful just in case. I'm guessing at some point that will come into play.
If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
Everything
Fair
to
enough.
everything to stall. Everything that can consume time, do it.
Did you talk to the deputies? Or
I
whoever
did. Thank you
to
for
talk-
that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later, if that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're gonna stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
So
Please.
I've been
And I will
told
have
there
to-
is a question that will be coming out shortly, so don't go.
From what I heard, he doesn't really took many showers when he was free. So I guess now he wants to take them all. That's what I heard in the comments.
Anywhere.
Don't choke me, Judge.
What?
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction. You knew I was about to say that.
Sir, I'm not going to address it. I already have. All right. I need to know the number to tell the parties who the fourth person is, because I'm not going to say the name on the record. They have a request for 3 exhibits, 15, 5, and 55. Number 11 is the fourth person.
You said 15, 5, and
55.
I was going to say, I don't know. I know 15.
15 is the map.
15 is the map, yeah.
Any objection to the map, sir?
Yeah, I want you to rule on everything.
Yeah.
Well, I was going to go one by one.
So you have any objection to that? And the quick answer is no. But let's see how much he drags it out.
So I'll start with Exhibit 15, which is the map. What's your position on that, sir?
My position is, at this point, what is the relevancy of the map? I think it's been seen.
Again, she just when she was saying about the objections and stuff, she told you that it was because no objection for relevancy can be made because they are relevant. Everything that they asked for is relevant because it was part of the trial.
A million times. I know it by heart now. That's probably the only one I know by heart.
Well, what's the state's?
And again, his argument is, why does it matter? And when you say like it doesn't matter, then it doesn't matter if they bring it or not.
Position.
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to work through, and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
Yeah.
All right, I will send Exhibit 15 back to the jury room. It is an exhibit, and there really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is Exhibit 5. That is the photograph of Erica Patterson.
Oh, I definitely object to that.
Definitely.
Seeing as how it was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So
Again, they didn't say it didn't happen. They just say that they didn't have enough proof to say that it happened. But that doesn't mean it didn't happen, Mr. Brooks.
I don't even. It's too dicey with that. What incident would 5 be referring to?
Well, if you're saying that one didn't happen, then there's only one incident, Mr. Brooks. You're destroying your argument as always.
Which
The
never
battery
happened,
count.
and then one. I don't even know what I'm looking at if I look at 5.
Again, he's shooting himself on the foot. He's saying that one of the incidents didn't happen. So if they have a photograph of Erica Patterson with the eye swollen, that means that it's from the one incident that you are charged with. So that means that you did do it. Not very bright.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
That's not why you're confused.
Well, there is an amended information, and I clearly instructed the jury on 76 counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video. How long is that video?
15 seconds.
Any objection to playing for the jury Exhibit 55?
What exactly is in Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck. We could put it up if you want to preview it, Your Honor.
Go ahead. And we would watch it at the same time as they're viewing it. Theirs is just be in the jury room. But I'll preview it for...
Did he just remove his mask to cough? Then why are you wearing it?
Mr. Brooks so he can see it first. All right. Your response, sir?
No response.
I'll just let you rule on it. There's so many videos that's kind of like the same video anyway.
Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds.
Any
Madam
reason
Clerk,
why
if
it
you
need to be played twice?
That's my practice, at least on short video clips.
So what about if they request for a long video?
Then I'll make a determination then.
I set for value and return for value these documents, Your Honor.
Thank you.
We're playing it one more time.
I'm still. I haven't watched those videos. I cannot do it.
All right, the video was played twice. We'll wait and see if they have any other questions.
Your Honor.
Yes, sir.
About this Reddit, is that how you say it, Reddit?
That's my understanding.
This particular person is who the email was sent from, the person at the top of the page?
Do you have the email that has the 9:10 a.m.? That's my understanding, yes.
Were they identified to have any connection with the trial in any way?
I'm leaving the entire investigation in the hands of the Sheriff's Department. I can't answer that.
Yeah.
I'm sure they're looking into it though, because that's a good question.
He's
All right,
so
I'm going to
confused by
step
that
off.
paper.
Obviously, the courtroom remains open, and we'll let you know if there are any additional questions. Procedures.
Subject matter jurisdiction, Your Honor.
I decline to address that, sir.
Will we be addressing it for the record?
It's been addressed. It's been addressed every day, at least once, mostly like 5 times. And it's been already addressed in a written response. So, what else do you want?
What's the significance of seeing it as different speeds? Was that in the question?
They just said, can we see Exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed.
Yeah.
So I'll grant the request.
What would be the significance?
That they want it.
The significance is the jury's requesting it, sir.
I'm saying at that speed.
They want it at that speed.
That's their request. I can't tell you the significance for them. I don't want to speculate. But I think it's proper, given the technology that we have available and what was done during the trial. So I will allow it.
So why even ask me if I have a position?
Because that's what I'm required to do, sir.
But you're not
You're supposed to say no, I don't have any. And that's it.
required to address subject matter jurisdiction, which hasn't been proven for the record.
Right.
Not allowed to answer any questions I ask.
Nope.
From your name.
Mr. Brooks, I'm not going to relitigate your case right now.
I mean,
And I've made my decision on subject matter jurisdiction, so your request that I address it once again is denied.
Yeah.
of course it's denied. Of course, because you can't prove it on record. Come on now.
I wanted to make sure.
It has yet to be proven. It has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
What song and dance? I would really like to know what song and dance he refers to. It's like a procedure that he knows about. It's something like that. I would really like to know.
That's 40% speed? Yay, nay?
He's really shocked that he's going that fast at 40% speed. Shame on you.
Now ended with the state just confirm the speed at which it was just played.
Yes, 40%, Your Honor.
Thank you. All right, let me know if there's another question. The court's going to step off. Obviously, will remain open. The 4-person provided a question through the bailiff. We request exhibits 3 and 4. Exhibits 3 and 4 are videos. They are the videos from White Rock, I believe, elementary school, door 1 and door 2.
Yes, correct.
How long are each?
6 minutes or something.
Is 6 minutes and 58 seconds.
7 minutes.
Okay. My inclination would be to play each one time, since they're a little bit longer, and play them one after the other. From the state?
Agreed.
From the defense?
Objection.
To what?
Noted for the record. Any specific reason, sir?
Nope.
The significance of both videos.
Is that they wanted to see it.
Their evidence, sir?
Great answer.
And the jury's requested to look at them. So I will be playing them for them. We'll do Exhibit 3 first, and then Exhibit 4 shortly thereafter.
Will you be addressing subject matter jurisdiction on the record?
No, I will not.
Is that a judicial determination, Your Honor?
Yes.
I can't. Oh, you're not asking me.
Is that a tacit agreement, Your Honor?
All right, they are ready.
Is that a tacit agreement, Your Honor?
Shut up.
Go ahead and play Exhibit 3 in its entirety.
They're finished with that.
I think you might want to stay close by.
Are we on the record?
We are in the record.
Subject matter jurisdiction?
Nope.
I decline to address that further, sir.
Will it be proven for the record?
Sir, my earlier decision, I stand behind it, my written decision.
Your written decision that's not based in any law or fact?
Yes.
I thought it was 2 people that got excused from the jury.
There were 15.
No, I'm saying I thought it was 2 from the 16.
No, only one.
Well, you did say 2.
When?
You said one had got excused before, and then another one was getting excused.
No, I only excused one. We've had 15 since the first juror was excused.
So what happened to that second one that had the COVID scare? What happened with that?
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
And why does that matter?
No need to get in your feelings. It's been a long day. I'm tired too.
I would
Tired
agree,
of what? You just sit there and talk.
But I'm not, I just letting you know I'm not going to rehash that stuff.
I just thought you said 2. You said 2 on the record.
How late is it? Like, if anyone in the comments know how late what this day was, I don't. It's like 10 p.m. something like that, midnight, because he looks like he's ready to sleep.
For the 12 who have
Did you see that? He was intently looking at the jurors, being like, "Bro, did you nullify? Did you nullify?" Each and everyone was like, he was like targeting to see their reaction and feel how they voting.
They started to deliberate. Do not deliberate unless you're in the jury deliberation room. And that will mean from when you are discharged here tonight until you come back tomorrow to decide the case solely on the evidence offered and received at the trial. With that, you are all excused for the evening. We'll see you back here tomorrow at 8:30.
Why is he doing this face?
All rise for the jury. All right, thank you, everyone. We are in recess. We'll see everyone tomorrow morning at 8:30. 8:30 a.m. I trust that the jail will give you a shower, so whether that's tonight or tomorrow morning before you come back to court. But I will order that.
In the morning. That's dead. 8:30?
8:30.
I'm not getting up that early. This gotta be some...
I'm not getting up that early. What else you had to do? Your life is on the line, and I couldn't sleep in that night. And he's happy?
night-type thing going on.
That's when we start court every morning, sir.
Yeah.
No, it happened then. You did some switcheroos.
Alright, and with that, we finish day 14. Quite a day. Man, a lot of things happening. He dragging his feet in order to stop stop it from happening. I believe that if he didn't do all this stuff with his closing arguments, we would have had the verdict now. Like by now, like oh, what time is it? It's 8:15. 8:15, and he was already sleepy. My guy, I don't know. I don't, maybe he stays up too late, but that's too early to be that like down on the table. But yeah, let join me next video to see the day 15, which will be the verdict. He's gonna drag his feet through the Reddit post, and then we're gonna hear the verdict of the jurors. So thank you for watching. Hope to see you next time. Give it a like if you made it this far. I'll see you guys in the next video. Bye bye.